Hello everyone, welcome to the U.S. Immigration. There's major news developing in Congress right now that could dramatically reshape the landscape for green card applicants and holders across the country. A bipartisan immigration reform bill called the Dignity Act of 2025 has been introduced in the House of Representatives, and it includes provisions that could affect millions of people waiting in green card backlogs. This legislation proposes some of the most significant changes to legal immigration we've seen in years, including a controversial $20,000 fast-track option for long-time applicants. Whether you're stuck in a years-long backlog, waiting for your priority date to become current, or simply trying to understand how immigration reform might impact your future plans, this bill deserves your attention. If you are interested in this topic and liking this video, please stay tuned until end of the video. If you are liking this video, please hit the bell button, subscribe and like it so that you may get updates straight to your smartphone. Now, let's get into the video. In a recent development that has caught the attention of immigration experts and advocacy groups nationwide, Representatives Maria Elvira Salazar, a Republican from Florida, and Veronica Escobar, a Democrat from Texas, introduced the Dignity Act of 2025 in the House of Representatives on July 15, 2025. This marks a rare moment of bipartisan cooperation on immigration policy at a time when the issue has become increasingly polarized. The bill, officially designated as H.R. 4393, represents one of the most comprehensive attempts to reform the U.S. immigration system in recent years. What makes this legislation particularly noteworthy is its dual approach, combining enhanced border security measures with significant reforms to legal immigration pathways that could directly benefit green card applicants. The Dignity Act is built on several foundational pillars. According to sources familiar with the legislation, it seeks to strengthen border security through billions of dollars in new funding for infrastructure and personnel. At the same time, it proposes establishing what sponsors call the Dignity Program, which would provide a pathway to legal status for certain undocumented immigrants who have been in the United States since before December 31, 2020. But for those already in the legal immigration system, particularly green card applicants facing massive backlogs, the bill includes provisions that could be genuinely transformative. Let's take a closer look at what this means for green card applicants and holders. The most talked about provision for legal immigration is the premium processing option for individuals who have been waiting in employment-based or family-based green card backlogs for 10 years or more. Reports suggest that under this proposal, eligible applicants could pay a fee of $20,000 to fast-track their green card applications and bypass the years-long waits that have become all too common, especially for applicants from high-demand countries like India and China. This is separate from existing premium processing services which only expedite the review of certain petitions but cannot bypass visa caps or priority date backlogs. Immigration experts note that this provision directly addresses one of the most frustrating aspects of the current system, due to per-country caps that limit how many green cards can go to nationals of any single country each year. Applicants from countries with high demand often face wait times stretching into decades. Under current law, only 7% of employment-based green cards can go to individuals from any one country annually. The Dignity Act proposes raising this cap from 7% to 15%, which could significantly reduce waiting times for applicants from countries that currently face the longest delays. Beyond the premium processing option, the bill includes another groundbreaking change that could effectively double the number of employment-based green cards available each year. According to the legislation, spouses and children of employment-based green card applicants would no longer count against the annual visa caps. Currently, when a primary applicant receives an employment-based green card, any derivative beneficiaries such as their spouse and children also count toward the annual limit of approximately 140,000 employment-based green cards. By exempting derivatives from these caps, the bill would allow the full allocation to go to primary applicants, potentially doubling or even tripling the actual number of families who can obtain permanent residency each year. The bill also addresses the situation of documented dreamers, a group that has received increasing attention in recent years. These are children who grew up in the United States as derivative beneficiaries under their parents' work visas. Under current law, when these children turn 21, they age out of their dependent status and must find their own pathway to remain in the country legally, despite having spent most of their lives in America. The Dignity Act includes provisions from the America's Children Act, which would protect documented dreamers from aging out and provide those who have maintained lawful presence in the United States for at least 10 years with an opportunity to obtain lawful permanent resident status. For dreamers and recipients of deferred action for childhood arrivals, the bill offers a conditional pathway to a green card. Individuals who arrived in the United States before age 18 could qualify for lawful permanent residency if they obtain a college degree or a post-secondary credential from a career and technical education school, serve in the U.S. military for at least 3 years, or demonstrate employment for at least 4 years while maintaining a work permit at least 75% of that time. They would also need to pass English language and civics tests. Immigration analysts estimate this provision could provide a pathway to green cards for as many as 2 to 3 million people. The Dignity Act also proposes reforms to student visas that could benefit international students studying in the United States. Currently, F-visa applicants must prove they have no intent to remain permanently in the country after completing their studies, a requirement that creates complications for students who later want to pursue employment-based green cards. The bill would remove this dual intent restriction, allowing F-visa holders to express interest in staying permanently without jeopardizing their student status. Additionally, the legislation would create a new family purpose non-immigrant visa, which would allow U.S. citizens and lawful permanent residents to sponsor relatives for 90-day visits to attend important life events like weddings or funerals, addressing a common source of visitor visa denials. However, before jumping to conclusions about when these changes might take effect, it's crucial to understand where this bill stands in the legislative process. As of now, the Dignity Act has been referred to multiple House committees, including the Judiciary Committee, the Homeland Security Committee, and the Ways and Means Committee for detailed review and consideration. Despite having bipartisan sponsors and over 20 original co-sponsors from both parties, the bill faces a challenging path to becoming law. Immigration reform has proven notoriously difficult to pass in recent years, and this legislation's fate remains uncertain in the current political environment. The bill's chances of passage depend on several factors. While public opinion polling has shown increasing support for comprehensive immigration reform, with recent surveys indicating that 78% of Americans support providing a pathway for immigrants without legal status to become citizens, the political dynamics in Congress remain complex. The legislation must navigate committee hearings, potential amendments, floor votes in both the House and Senate, and ultimately secure the president's signature to become law. According to political analysts, without support from the Trump administration, which is, focused heavily on immigration enforcement and deportations, the bill's prospects are considered challenging at best. What this means for current green card applicants is that, uncertainty remains. Those who have already filed applications and are waiting in backlogs cannot yet count on the proposed changes taking effect. Immigration attorneys advise that applicants should continue with their current processes and not delay their applications in hopes that this legislation will pass. Even if the Dignity Act does become law, implementation could take months or even longer, since agencies like U.S. Citizenship and Immigration Services and the Department of State would need to develop regulations, establish new programs, create digital systems, and allocate resources to actually handle the changes. Despite these challenges, advocacy groups have rallied behind the legislation. Organizations representing business interests, faith-based communities, and immigration advocacy groups have, voiced support for the bill's balanced approach. The Essential Worker Immigration Coalition pointed out that at a time when labor shortages continue to challenge employers across sectors like hospitality, healthcare, construction, and agriculture, the Dignity Act offers solutions to help stabilize the workforce. Faith-based organizations, including World Relief and the Asian American Christian Collaborative, have expressed support for the bill's combination of respect for the rule of law with compassionate treatment of long-standing community members. The bill also includes enforcement provisions that reflect its bipartisan nature. It would mandate nationwide use of E-Verify, an electronic system for employers to verify work eligibility, replacing the current paper-based I-9 verification system. The legislation increases penalties for illegal re-entry, raising the maximum prison sentence from 2 years to 10 years for individuals who unlawfully return to the United States after being removed. These enforcement measures are designed to appeal to lawmakers concerned about border security and immigration enforcement. In practical terms, if you're currently in a green card backlog, immigration experts suggest several steps. First, continue pursuing your current application without delay. Priority dates and queue positions matter, and waiting for potential legislation to pass could cost valuable time. Second, stay informed about developments regarding the Dignity Act by following official sources like Congress. Third, consult with an immigration attorney who can provide guidance specific to your situation and help you understand how potential changes might affect your case. And fourth, consider whether the $20,000 premium processing option, if it becomes available, would be financially feasible and strategically beneficial for your circumstances. The situation remains fluid and several outcomes are possible. The bill could pass in its current form, though this seems unlikely given the complexity of immigration reform. More probably, it could undergo significant amendments during the committee process, potentially changing key provisions like the $20,000 fee or the eligibility criteria for various programs. It could also stall in committee and never reach a floor vote, which has been the fate of many immigration reform proposals in recent years. Alternatively, portions of the bill could be extracted and passed as standalone legislation addressing specific issues like documented dreamers or per-country cap reforms, while leaving more controversial provisions behind. For green card holders, the bill includes provisions that affect the broader immigration ecosystem. The proposed expansion of legal immigration pathways and the reduction of backlogs could make the overall system more efficient, potentially reducing processing times even for routine applications. However, the bill also includes enhanced documentation requirements and enforcement measures that could increase scrutiny of immigration applications across the board. Looking at the political landscape, the timing of this legislation is significant. It comes as the Trump administration has ramped up immigration enforcement actions, leading to increased detentions and deportations. This has created tension between federal immigration policies and the desires of many communities, businesses, and advocacy groups for more stable and humane immigration practices. The Dignity Act represents an attempt by some members of Congress to chart a different course, one that balances security concerns with economic needs and humanitarian consideration. Immigration reform has been called the third rail of American politics for good reason. Previous attempts at comprehensive reform in 2006, 2007, and 2013 all failed to become law despite significant effort and negotiation. The question now is whether the unique combination of circumstances in 2025, including shifting public opinion, pressing labor shortages, and the bipartisan coalition behind this bill, will be enough to break through decades of legislative gridlock. Legal experts remain cautiously skeptical, but acknowledge that the introduction of such comprehensive legislation keeps the conversation alive and potentially sets the stage for future negotiations. For those watching from outside the United States, the Dignity Act's provisions could also affect consular processing timelines and visa availability. If the per-country cap increases and derivative exemptions take effect, more visa numbers would become available each year, potentially shortening wait times at U.S. consulates abroad. The bill also provides appropriated funds to the Bureau of Consular Affairs and Visa Services at the State Department to reduce delays and improve visa processing capacity. That's all we have for this bulletin. The U.S. Immigration Hub channel provides all necessary visa information and procedures for your U.S. immigration journey. It's important to understand the United States immigration processing steps, visa application requirements, processing times, forms, fees, and, more. We'll continue to provide all information about U.S. visitor visas such as B1 and B2 work visas, like L1A, L1B, and H1B student visas, green cards, immigrant visas, EBONI, E2, F3, EB4 and F5, and family immigrant visas. Thank you for visiting us today, and we'll see you in the next video. If you haven't subscribed to our channel, U.S. Immigration Update video.